Hey out there, legal warriors. Why should you always request a Department of Licensing hearing in Washington State, at least in my opinion? Are you interested in hearings, Department of Licensing issues, what you should do if you face some type of DUI licensing action? Are you interested in that, or does someone you know have that type of situation? If so, stay tuned because this is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington, and my law firm has been defending people charged with crimes all throughout Washington State for more than 20 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. I'm just going to jump right into it. Yes, in my opinion, you should always request a Department of Licensing hearing if you're pulled over, stopped, investigated, arrested, etc., for a DUI charge in Washington State. So let's cover, when does this apply, right? Well, in Washington State, if you're an adult, 21 or above, and you are driving a motor vehicle, you're pulled over for a DUI, or you're stopped in your car, physical control like a DUI, and you either refuse a breath or blood test, or you blow 0.08 or higher alcohol on a breath test, then Department of Licensing is going to take a licensing action against you. It can also happen if a blood result comes back well after the stop and you have 5 nanograms or more of marijuana in your blood, or 0.08 or higher alcohol in your blood in the blood draw. And if you're a minor, there's whole different things involved. The limit for a minor for an alcohol suspension basically is going to be much lower, and the same way for marijuana is basically any amount is going to trigger suspension for a minor. So in that situation, you're likely been given a piece of paper by a police officer saying, hey, here's a driver's hearing request form, and that's going to say that you have 7 days from the date of the stop to actually request a licensing hearing to contest the suspension of your license. Okay, so on a first administrative action, if it's your first DUI stop with a breath test above a 0.8, you're looking at a 0.08, you're looking at a 90-day license suspension. If you've refused a breath or blood test, you're looking at a 1-year license suspension. If it's a second administrative action, within 7 years basically, then you're looking at a 2-year license suspension, and that's just on the administrative side. That's not even the court part, right? And so you do want to request that licensing hearing. And how do you do that? Well, you fill out the form, and you have to pay, as of filming this, which is in August of 2022, you have to pay $375 to request the hearing, or there's a form where you can claim indigency where you don't have enough money and see if they'll waive that. You need to mail that into Department of Licensing, postmark within 7 days, or you can go to your licensing express account at www.dol.wa.gov, where you renew your driver's license, renew your tab, stuff like that, and request a DUI hearing. And again, 7 days from the date of the event, day 1 being the day after the officer claims the event happened. So you always want to try to do it early. So why do you want to request that hearing? Well, number one, it puts off any suspension of your license. More time is better, right? So basically right about 30 days after the event is when your supposed license suspension is going to start, and they're going to send you a notice telling you that. If you requested the licensing hearing properly, that suspension is going to be put on hold until an actual hearing happens. So the first reason is it's going to delay a suspension, okay? The second reason is you're going to be able to get the police reports, right? Because when you request a licensing hearing, the hearing examiner, the person who makes a decision at the hearing, is required to send you the exhibits that they're going to rely on to determine whether or not there was, a violation of the law. And that's going to be an exhibit that's the entire police report that the officer wrote. And there's also going to be some other things like some thermometer certifications and things that are more legal. But it's your chance very easily to get the report and see what was written about you. So just to have that is useful, right? It's also useful to take to an attorney, things like that. So not only are you delaying your license suspension, you're also getting a copy of the police report. So why else? I'm spending $375. Why should I do this, Lance? Well, especially if you have an attorney, there's a chance, and the good attorneys will most likely end up subpoenaing the officer, making the officer show up on the telephone at a licensing hearing date to testify about what happened. So it's a way for your legal team to gather some evidence that otherwise we wouldn't be able to gather, right? We're going to be able to ask the officer some questions under oath while they may be at home just relaxing. They may not be on shift, and sometimes we're going to learn some things about some mistakes they made that we otherwise would not have learned, okay? And learning that stuff is really important. And under oath, while recorded, means we can actually use it, right? And so even if the officer testifies mainly correctly, they may testify they did the field sobriety test differently than what's required by the manuals, right? They may be unclear about the reason for the stop. We could get some problems with the breath test room, the observation period that the officer has to do. So there's lots of things that we can get. If you request a licensing hearing, now we've got the right to make that officer talk to us under oath and on the record, right? So then what's number 4? Well, we might win the hearing and cancel the suspension, right? You can only win a hearing and cancel your suspension if you've requested the hearing, right? So how do we win the hearing? Well, if we subpoena the officer and the officer doesn't show up without excuse. If we've done things correctly, we can make a motion to dismiss under Lytle v. Department of Licensing, a due process violation because they're taking your property right, your driver's license, and we can dismiss that way. What's another way we can win? The officer testifies so poorly that the hearing examiner dismisses the case for a bad arrest or a bad stop or bad procedures, right? Dismisses the administrative action. That may or may not make your criminal case go away altogether, but it's definitely going to help your criminal case, right? So getting that suspension canceled and helping your criminal case could also happen by requesting a hearing. So what's another reason to request the hearing? Well, there's no downside, right? The only downside to requesting the hearing is the time and the money. It's a fair amount of money, $375, but this is an expensive process going through a DUI. And so relatively for the overall cost of a DUI, that's pretty cheap compared to everything else. And so you get a lot of bang for your buck because you might win the hearing, you might get evidence that helps your criminal case, you're going to delay any possible suspension regardless, and it's not going to make matters worse. There's no penalty. They don't say, well, because you requested the hearing, you're going to get a worse suspension. No. That's not how it works, right? So the worst that could happen is at some future date, the Department of Licensing affirms the original suspension decision and gives you a new suspension start date. So those are all basically 5 good reasons why you should request a licensing hearing. There's only an upside. You might win, it delays things, you'll get professional help hopefully, and if we suffer a suspension, we'll be in a better position in the future to plan for it, right? If you are suffering a suspension, there's a good chance you'll be eligible for an ignition interlock license, and we have videos about that in this channel, and that means you hopefully can keep driving if you follow certain rules with the interlock during a period of suspension. If you don't request that licensing hearing, all that is lost. All these chances for gain or loss. You've got a suspension starting in 30 days, and it's just a shame when we don't request one. So there's a time limit. Do it quick. Do it right. Contact an attorney to help would probably be the best idea, but it's really important that you do it because it's one of the best tools we have to fight back with very little risk. So I hope you found this useful. If so, please like and please subscribe. More people will get to see this and get the help they need. And if you have this type of situation, if you have a DUI or something similar, feel free to give my office a call. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.